first speaker, Dr. Helen Watchirs, is, as I said before, the ACT Human Rights and Discrimination Commissioner since 2004. She didn't give me any embarrassing or not embarrassing information on herself, so I'm just going to tell her what she's done in her life and is currently doing. Since she became the ACT Commissioner, she has conducted the ACT, the audit of the ACT detention facilities, which was a major audit in Canberra. She has supervised the handling of about 1,000 complaints in her career there. She has worked previously for 30 years as a human rights lawyer, not only in Australia, but also for the United Nations. And she's done her PhD, which has focused on human rights and health, and particularly HIV. And this will link her to the next speaker, who has also a background in health law. So please welcome with me Dr. Helen Watchirs.
Thanks very much. Always good not to be embarrassed. What a beautiful Canberra autumn day, and particularly welcome international visitors to our city here in Canberra. Thank you for CEPS for inviting me to speak today, particularly Simon, who's been a colleague over the last 20 plus years at the ANU before his present job. What I'm going to talk about is police and human rights compliance under Australia's first Human Rights Act. It was enacted in 2004 and came into force on 1 July. Victoria also has a Charter of Rights and Responsibilities 2006, and that came into force in 2007 and 8. I'd like to start by acknowledging the traditional owners of the land on which we are Ngunnawal people and pay my respect to elders past, present and future. Many speakers have mentioned how appropriate it is to be celebrating a 50th anniversary of the UN conference that was held here on human rights and policing. This is also the 65th anniversary of the UN Declaration of Human Rights, in which Australia played a very key role in developing. This declaration and the many treaties following it were because of the horrors of genocide and global war, which made human rights a concern that wasn't just domestic. And some human rights, such as torture, should not be breached in any circumstances. They have an absolute prohibition. What stands out in our region is Asia Pacific is the only region without a human rights regime or convention. So we're basically our law and then the UN. There's nothing in between. Probably due to cultural issues, much more focus in Asia on communal rather than individual values. I agree absolutely with Professor David Bailey. Yesterday talked about the last 50 years have been incredible change in terms of consciousness and awareness of human rights, and we've seen this at the local level with our own first Human Rights Act. In order to develop a human rights culture, there are usually 3 stages. Firstly, awareness, engagement, and finally commitment. And I think we're stuck between engagement and commitment. Probably we have a little more way to go. What that means is having a pattern of assumptions and shared values that human rights are considered and respected in carrying out all functions, developing and evaluating policy, services and programs, and I'm going to talk about that in relation to the police. It is really important to have human rights accountability and meaningful forms of measurement to prevent backsliding, and my PhD was on human rights auditing in the HIV and AIDS area in Australia and also Cambodia for the postdoc. It's particularly important because of the new opportunities police have with technological advances and social media intelligence. I didn't know what SOC meant until I prepared for this conference. It means social media intelligence, which really seem to have skyrocketed in the UK since the August 2011 riots with Flickr and Twitter, things like #ShopAlooter, and for good and bad uses, but certainly a lot of information's out there. There is an inherent tension between police powers and human rights. Security is a ground of actually proportionate restrictions in most human rights treaties, but as several speakers have said, there is actually a synergy between the human rights culture when that's embedded in the police and where they're trained to protect the rights of people under the democratic rule of law. And the most obvious to people on the street is liberty and security of the person. So personal safety is how people perceive that. Police do form many human rights functions, just not with that label. Investigating hate crimes against the LGBTIQ community, racial vilification, called communities, sexual assault, and special units for victims and vulnerable witnesses such as children, people with disabilities and cognitive impairments. And there was a really great session on this half of the room about vulnerable people today. And I noticed in the media last week, Manchester Police are actually targeting hate crimes against goth punks and emos. So that's one update from the presentation this afternoon on that topic. In an ideal environment of trust and respectful relationships, the police and the community should reflect each other in order to have effective partnerships and work towards common goals. So modernised, participatory and open police are very different from the old of closed, hierarchical and militarised, but I think we're still not quite there in terms of modern and open. There is quite an influence in Australia of European literature because of the Human Rights Convention and regime there. And there are UN handbooks on teaching human rights to police officers. In 2006, Amnesty International did a manual in the Netherlands called Understanding Policing, and they're quite good resources. The UK has its own Human Rights Act, 1998, came into force 2000, and there have been lots of things post that legislation that has influenced policing and indirectly will influence Australia. The Lawrence Inquiry report in 1999 and the Patten Commission, a few people have mentioned, in Northern Ireland of the same year. However, with that model of policing being legitimate, accountable, visible, compliant with law, minimal use of force and public engagement, there are studies that have said that the institutionalisation has been more conformity with bureaucratic processes rather than active consideration of human rights. And that's Bullock and Johnson, 2011, Department of Sociology, University of Surrey. They used qualitative interviews with police, and they said that it had become a framework for mandating existing police practices and protecting officers from blame. In this morning's session, there was mention of Peter Nehru's book. Here it is. Have a quick look at Lunchtime, Policing Ethics and Human Rights, which has a great section on auditing human rights and how that happened just after the Human Rights Act was passed there. There is a human rights guidance for police authorities, and since 14th of March 2008, there's actually been a specific duty to monitor compliance by the police. So that's self-reporting with some external input. And it does highlight that it shouldn't be an excessive burden to do this in human rights terms because it's complementary to the duties to be efficient and effective as a police force. Good record keeping in respect of decision making actually should record necessity and proportionality of discretionary decisions made by police, so you're actually protecting your own back as well as giving reasons for up the chain of command or if there's a review or internal review sought by the accused. ACT policing is part of the Australian Federal Police. There's an annual purchase agreement. It's very good value for the ACT. It's a very expert force. The AFB like it because it gives operational experience across the whole gamut of crime in a small community. Under the Human Rights Act, ACT policing is explicitly named as a public authority. Thereby, they must act and make decisions consistently with human rights when exercising functions under territory law, and I emphasise territory law because if they use federal law, Human Rights Act doesn't apply. Unfortunately, because it's a federal agency, it's not subject to the ACT Discrimination Act 1991, but that's being reviewed by the Law Reform Advisory Council. I'm hoping that we can come to some compromise that at least we can provide some oversight. The Ombudsman, of course, does do oversight of the Federal Police and the ACT Police here. The Federal Racial Discrimination Act does apply, and yesterday there was a great session by Chris Caneen about the February settlement this year of a case against Victoria Police by racial profiling of African young men, and there was evidence that they disproportionately and arbitrarily stopped, searched, questioned, taunted and allegedly assaulted police, and one of the outcomes was cross-cultural awareness training. I am aware the Commission there has been working on unconscious bias, and I'm hoping she's linked into Judy Saba, who spoke about her form of training in the New South Wales Police, which is very impressive. There have been some controversies, tasers. There have been deaths in Sydney and Brisbane of people having tasers used on them, and Amnesty International has had criticisms of the use of them. The ACT Ombudsman, in the rollout of tasers across the AFP, recommended that cameras be attached, and that has happened. So now there is some record of whether they're actually being used for the purpose of de-escalation and not punishment. The Ombudsman looked at the Watch House in Civic and found inappropriate uses of Capsicums Ground detainees, and those cases, most of them have been successfully prosecuted against police. The mandate of the Commission's formed of 3 commissioners. I'm Human Rights and Discrimination. We have a Health and Disabilities Services and a Children and Young People Services Commissioner. My work is focused on correctional facilities. We did the Youth Detention Centre in 2005. That was upgraded to a new facility called Bimbury, and we did a joint review. It's about 800 pages. You can see it there on the desk with the Children and Young People Commissioner. And lastly, we're currently doing an audit of the adult Alexander McConaughey Centre in respect of women, only because of our lack of resources. It fits 300 detainees, only 15 are women, but we've picked off that portion as being concerned about any systemic discrimination issues as well as human rights, which should reveal some of the treatment of the men as well. We did an audit back in 2007 of our remand facilities, which were appalling. They were similar to the Kittingal building in Sydney, which had been demolished, and it was tiny and really overstretched in terms of resources. In relation to young people, we found data from the Australian Institute of Health and Welfare. Their statistics said that Indigenous young people were 35 times more likely to be detained in the ACT than non-Indigenous young people, and that's something that's we're working towards in the whole youth justice system, trying to get some reform. The Human Rights Act has several ways of implementing itself. The Attorney-General must issue compatibility statements when he has a government bill that's tabled, and also the Legislative Assembly Scrutiny Committee looks at it. The Federal Human Rights Framework is fairly new and has those 2 pillars as well, and it does have a legislative basis. But the ACT goes further because we've got the enforcement mechanisms of individuals can litigate if there's a violation by public authorities. There's been a mention of over 190 cases of human rights in the ACT, but none squarely on that specific violation. In Victoria, there have been about 360 plus cases, so we're not finding big violations. It's a process of continuous improvement in terms of law and practices and policies. It's really important to engage the community in drafting human rights compliant laws because that affects police powers and discretions, and so people know in advance what is a crime and what's not. Anti-terrorism legislation in the ACT was, as Brett Walker said this morning, extraordinary. In 2006, our bill was called the Terrorism Extraordinary Temporary Powers Act 2006, and it's quite different to every other jurisdiction and far superior to the federal model. The type of rights are engaged in really far-reaching liberty, fair trial, family, association, communication movement, privacy, because of preventive detention orders as well as control orders. They do, it's like there's a whole separate and parallel executive system for preventative crimes compared to where crimes have actually occurred, and then you get the full criminal justice system with fair trials. In the ACT, you need an authorisation by court for special powers. It's not the police issuing it. It does not apply to a child as it does in the federal area. There must be an interpreter. The Ombudsman and the Commission must be notified. There is a presumption of confidentiality of legal communications. Then people are not held incommunicado. You're actually allowed to tell your family where you are. Under the federal scheme, you'll be subject to a 5-year term of imprisonment if you tell your family where you are illegally, and legal assistance is available. The only contra to how good that act is, it's never been used, so we don't know how practical it is, but it only had a 5-year term, a sunset clause, and has been reenacted, but it's a lot better than other legislation. So that kind of process of looking at human rights angles and getting the legislation improved is an ongoing process. At the moment we're looking at sex work legislation, and at the moment the DPP's pressuring a COAG project on double jeopardy reform. There's also a very big ongoing project of these powers and a working group, things like use of force, intoxicated people, powers of arrest, questioning, having times stop and start when people are in detention to satisfy statutory requirements, use of interpreters, stop and search powers, and search warrants. A very controversial issue in relation to these police powers were the anti-bikie gang laws in 2009. It's part of my role to advise the attorney. He requested advice, and I said if we repeated the South Australian New South Wales legislation, there's no doubt in my mind that a declaration of incompatibility would be issued by the Supreme Court, because it's absolutely not human rights compatible. It operates declaring an organisation illegal, much like anti-terrorism powers, and then control orders about where people can associate or even work in terms of industries such as motor vehicles. Both the South Australian and New South Wales laws have been overturned by the High Court as unconstitutional, but the Queensland legislation is still standing after a High Court challenge. There have been other specific police issues, such as wanting to remove self-defence for the accused where they're being detained by the police and they're fighting back. That legislation's been challenged. Sentencing guidelines to try and make assaulting a police officer an aggravated offence compared to a normal citizen. And one we're quite happy to get a victory on was the average speed cameras that were installed in the ACT. It was originally going to be captured by cameras at the front of the car, but we were worried the potential use of the data in the future that you get for face recognition if you had the front number plate, so we were able to convince the attorney to have it on the back of the car so you can't see the person who's in the car. That would be collecting information for a different purpose and, in my view, unauthorised. There have been increasing cases of us not being successful and warning the government that legislation in our view is not compliant, and that's over a 9-year period, not surprising I suppose, but the whole idea of a Human Rights Act is that it's a dialogue model. The court doesn't get to trump the legislature. It's not undemocratic. What happens is the Supreme Court will issue a declaration of incompatibility, the attorney tables it, and then there'll be a government response. There's only been one in the ACT and one in Victoria. In the ACT, the case is Islam, and it was in respect of the Bail Act. It said that in certain cases of crime, such as attempted murder and some drug offences, you were automatically deemed not to have bail. You couldn't look at the ordinary features of why you would not grant bail, such as if you're a flight risk. Similarly, in Victoria, Momcilovic, which went to the High Court, it found that the Victorian Charter was constitutional. It deemed possessions of drugs as automatically amounting to trafficking. We've copied this to our detriment in the ACT, and both the Commission and the Law Society opposed the government legislation. It deems possession of control precursor, that is something like a Sudafed tablet of any quantity, means that there is a presumption of manufacture, and that's a 7-year indictable offence. So that reverses the legal onus. It's up to the accused to prove that they did not intend to sell any pharmaceutical items they may have at home, such as to make home-baked heroin. We also lost on roadside drug testing. Chief Minister Stanhope was quite keen, and we managed to turn him around, but that reversed. In our view, there is no link between the presence of illicit drugs and the evidence of impairment to drive. There's a huge amount of literature in terms of the amount of alcohol and how that impairs driving. Australia was, I think, the first country in the world that had random breath testing for alcohol. We said you don't have that evidence for drugs, particularly if you're just looking for the presence rather than an actual amount to cause impairment. To lower that breach, we said, well, maybe if you were stopping them anyway for an alcohol breath test, you could do that, but they still didn't agree. They pressed on, and we have random drug testing. So there have been 17,000 tests, and only 33 have been positive, and it's cost over $1 million in the past 15-month. Court cases, there has been a bit of reluctance of the local bar and solicitors to engage in the Human Rights Act because there are no damages available. It's declarations and other kinds of remedies. However, I do have a power to seek leave to intervene, and there was a case called Morrow and Ahadizad where people have been kept beyond their detention. There was a mistake by the Sentencing Administration Law. So there's no question they were unlawfully detained, and we successfully argued they should be compensated. The UK, you can get compensation. It's quite limited. But that was really important precedent that unlawful detention could result in some kind of compensation. A big development at the national level is the impending ratification of the optional protocol on the Convention Against Torture. We signed it in 2009. February last year there was a national interest analysis tabled in Parliament. June last year the Joint Standing Committee of Treaties unanimously recommended ratification, but they're still dragging the change at the state and territory level. ACT has been the first jurisdiction. We've got monitoring places of detention, OPCAT Bill 2013, and in preparation for that ratification coming. As when I was introduced, we have focused on talking about monitoring human rights in places of detention. That does include police cells, and we have looked at when there have been architectural plans about making them more human rights compliant about people who are being kept there. Rehabilitation is incredibly important in terms of impacting on recidivism rates, and at the moment there's a justice reinvestment project that is intensive community support to prevent social problems becoming criminal problems in terms of the over-representation of Indigenous people, people with mental health and substance abuse problems. So I think there's between 6 and 10 families that are going to be identified for intensive preventative interventions, and it's going to be very interesting how that comes out because the ANU wants to do an ARC study on how effective that will be. Buildings alone are not going to fix human rights issues. They do fix overcrowding and inappropriate mixing of detainees, but it's really the culture of corrections and police staff who run those facilities that are important. Under international law, governments are legally responsible for implementing human rights treaties, and partnerships with civil society is really important, and that legitimacy in policing is essential to get that partnership going. No law can be a magic bullet to fix complex social problems. Human Rights Act is a good step forward. It is of substantive as well as symbolic impact. I think it has changed policing in the ACT. I'd like to see more, but of course police powers are determined by legislation, so the quality of that legislation is the first step, and scrutiny has improved that. We know through, for example, the anti-terrorism laws that having scrutiny of human rights means you'll get better legislation that's more compliant. And there's been much more community debate about human rights and police powers. You'll see that in the media, whether it's television or newspaper or radio, and that's been an increasing process. I think the big issue is translating human rights legal requirements into the daily practice of police on the beat and in investigations, use of force, weaponry, exercising search and seizure powers, and really that is a process of continuous improvement. Thank you.